Good afternoon. My name is Jonathan Scriven. I'm the Associate Director of the Honors College here at Washington Adventist University. I'm the Director of the Center for Law and Public Policy. On behalf of our President, President Spence, on behalf of our Provost, who is here, Provost Kasinzu, and on behalf of the Director of the Honors College, Bradford Haas, I would like to welcome all of you to this special presentation and panel discussion that is being held as part of WAU's Constitution Day programming. Each September 17, in honor of Constitution Day, colleges and universities that accept federal funding are required to put on educational programming for students and the wider community that focuses on some of the aspects of the United States Constitution. Because September 17 falls on a Saturday this year, my colleague Brad and I brainstormed with Nicholas Miller, who you will hear from shortly, and decided to put on this event, one that focuses on how Supreme Court decisions impact religion and religious liberty in this country. Today's event is a joint effort sponsored by not only the WAU Honors College and the Center for Law and Public Policy, but also the International Religious Liberty Institute of Andrews University. We are pleased to welcome students and faculty members from around the country via our live stream service today, and particularly those who are part of a new initiative within Adventist higher education, the Adventist Pre-Law Society. In the coming weeks and months, you will hear more about this initiative, and we are very excited about some of the opportunities that it will create for our pre-law programs at Adventist colleges and universities in the North American Division. The format of this afternoon's event will be as follows. We will first hear a short presentation from Professor Nicholas Miller. After the presentation, we will have time for our panelists to speak about various legal issues related to several Supreme Court cases, and we will conclude with a Q&A period that I will lead. If you would like to ask a question, and this is both for those of you here at WAU or for those watching on our YouTube channel, I would like you to email me any questions you might have, and I will then address those to the panelists. My email address, if you want to write this down very quickly, it's very simple. It's jscriven, that's JSCRIV, as in Victor, EN, at wau.edu. I'll repeat that address, that email address when we have our panel. We hope to get to as many questions as possible. I would like to also take a moment to thank our campus church, Sligo Seventh-day Adventist Church, for hosting us this afternoon in this beautiful atrium. Sligo is an important partner for WAU, and we always relish opportunities to collaborate with Sligo. Sligo's senior pastor, Alex Barrientos, who is a graduate of WAU, will offer now our opening prayer.
Oh, good group. Good afternoon, everyone. Good to see you, and glad you could make it out to have a wonderful conversation in relation to how perhaps by implication God is engaged in the world, and perhaps how faith is, in a sense, engaged in spheres of multiplicities of conversation in light of networks in the world. So let us pray as we think about what that might imply for us today. Let us pray. Father, we thank you so much for the invitation to allow us to be within your sphere. You created the world, and you are a remaining constancy within it. You are not another thing in it, and yet you provide the energy for it. How these conversations impacts what we do at a broader sense or a narrow one, we ask that the faith that we know in you provides the constancy of justice, of mercy, of compassion, of forgiveness, of the reality of what we are in light of who you are towards us. We thank you that in Jesus there is perspective, but not in simply wishful thinking, but that you reorient what it means to be human in this world because of Jesus. We thank you for your Spirit's guidance, through whom we have existence and breath, you who sustain all things. We ask that you teach us how to be human, but to be human next to other human beings. We thank you for this blessing. Bless our conversation. In Christ's name we pray. Amen.
It is my great pleasure to introduce our speaker for this afternoon for a short presentation. Professor Nicholas Miller received his BA in theology from Pacific Union College and a law degree from the Columbia University Law School, where he was an editor of the Columbia Law Review. He also has a PhD in American Religious and Legal History from the University of Notre Dame. Nick has argued many church-state cases in state and federal courts and has appeared before the United States Supreme Court in the case of Mitchell versus Helms, and is the author of more than 30 scholarly and professional journal articles and book chapters dealing with issues of church, state, and society. His book on the development of religious freedom in America, titled The Religious Roots of the First Amendment, was published by Oxford University Press in 2012. Professor Miller currently teaches both for the seminary at Andrews University and here at WAU for our pre-law program, where he teaches about the American judicial system, and he coaches the WAU mock trial team. It is with great pleasure that I introduce you now to Nicholas Miller.
Thank you for that gracious introduction, Jonathan, and thank you to yourself and Dr. Haas as well for helping make this event a reality. It's great to collaborate between our institutions. I think we live in a time of significant division, both in our society as well as in our church, and we need more working together. And that's what this is an attempt to do, not just Washington Adventist University and Andrews, but also some of our friends from the North American Division, as well as Adventist lawyers in the community. I think it's especially important that we do this as Adventists, because I believe that we are heirs of a more moderate strand of legal and political thought that is not exclusively or even primarily Adventist, but which goes under a broader name of free church or dissenting Protestant thought. Now, we're all aware, hopefully at this point, that not all Protestants in the early modern era were great champions of religious freedom. John Calvin in his Geneva famously burned a man for not believing properly about the Trinity. The Puritans hanged a few Quakers in their time in New England, at John Cotton's Massachusetts. But there were other Protestants, including early Martin Luther, the Anabaptists and Quakers, Baptists, Scotch Free Church Presbyterians, that took a different approach to these matters. Dissenting, that word dissenting comes from disagreeing with the magisterial high church approach by the Anglican, Lutheran, and Calvinist churches. So these groups believed in a separation of the civil magistrate from the church itself. They didn't believe in a separation of morality in the state necessarily. They thought the state had a role in safeguarding basic public morality as revealed not in the Bible, but in what they would view as natural law. It's a heritage that appreciates the separation of church and state, that spiritual values and truths should not be promoted by state means, but also recognizes that liberty is not licensed, that ordered liberty can only exist when civil virtues and morality have some sort of protection by law. Now, this combination of morality and liberty has become rarer in Protestant circles during the middle of the 20th century. Notions of natural law and moral philosophy were victims of the fundamentalist modernist split that impacted Christianity in the early 20th century. Conservative Christians retreated from a robust moral philosophy to a sort of Bible-only moral framework that sounds good in Sabbath school, perhaps, but can't be used to support public policy issues. Interestingly enough, Ellen White herself said that moral philosophy is one of the 3 topics we should especially study in our schools, along with the Bible and physical education. Liberal Christians, on the other hand, retreated to a world of pragmatism and legal positivism, no longer interested in connecting the phenomenal or natural world and the noumenal or metaphysical worlds. This left the public policy of the 20th century in America largely to secular liberal ideologies developed by the progressives in the early 20th century, with some rearguard opposition from largely Catholic and some secular traditionalist political and legal philosophers. Have you ever wondered why, with the resurgent conservative influence on the Supreme Court, that this has been led almost exclusively by Catholic jurists? Until the recent appointment of Ketanji Brown Jackson, there really weren't any Protestants on the court. 6 or 7 Catholics. Neil Gorsuch was raised a Catholic, though attends a high Episcopal church. A couple of Jews. So it was remarkable that a country known as a Protestant nation had no representation on the high court from the single largest religious group in the country. Explained, I believe, by this development in philosophy where Protestant thinkers largely abandoned the field, either joining the secular thinkers or leaving moral talk about the law to Catholics. So when we come to a place in our political history where we're wanting a more conservative outlook, the only people to really turn to, or that's the way it seems, are those educated in the Catholic jurisprudential natural law tradition. What is overlooked in all of this is there was a robust Protestant legal and public philosophy that flourished for some centuries that contained such luminous names as Hugo Grotius, John Locke, James Madison, and Supreme Court Justices John Marshall Harlan, the great dissenter. We might include Justices Thurgood Marshall and even Sandra Day O'Connor in more recent memory on this list. I give this somewhat extended historical overview to underscore the importance of this event and the groups that are sponsoring it. We are not only trying to guide Adventists and other young Christian people into a life of serving God and their community in the life of law and public policy, but we're also trying to breathe life back into an important public philosophy that I believe can serve as a bridge builder between political extremes and protectors of minority rights and freedoms during an increasingly intolerant time. And have you noticed the intolerance is on both the left and the right, where woke warriors on the left clash with Christian nationalist insurrectionists on the right? A middle ground has never before, at least in my lifetime, been so urgently needed. For those interested in knowing more than I can say in this presentation about a middle ground, I refer you to the book that's on the table on your way in. The first 50 people can have a copy of my book, 500 Years of Protest and Liberty, from Martin Luther to Modern Civil Rights. And I try to trace this development of this philosophy with its roots in Protestant theology, brought to America over the years and forming our constitutional framework. I've donated copies if you would like to give a donation to the WAU Center for Law and Public Policy. I'm sure they wouldn't turn it down, but the book is yours to take. Let me begin. I am assessing the recent Supreme Court cases through a philosophy shaped by this alternate dissenting Protestant heritage. This last term, the court decided several cases of importance to civil rights generally and religious freedom in particular. And let me start with the case of Carson versus Macon. This is the case that held that the state of Maine could not provide tuition aid to students at rural private schools without also sending that aid to students at private religious schools. Maine is a large state with a large, far-flung population. There are some places where public schools don't exist, so the state created vouchers for those students, but would only allow those students to attend private secular schools and excluded religious schools. The notion of vouchers goes back to a decision in the early 2000s, the Zellman case, where the court said that the state could allow vouchers that went to private citizens to be used at religious schools. But their latest decisions differs in that it says not only can the state allow vouchers to go to private religious schools, but that if it allows that to happen, then it must allow them to be used at religious schools. So how much of a difference is this? Is it a vindication of the right of religion and religious people to be free from discrimination, as the majority said? Or is the sky falling on the constitutional separation of church and state, as well as on genuine religious freedom, as the dissenters and our friends on the political and ideological left assert? Which assessment is more accurate? Well, I've entitled my presentation here, Confessions of a Church-State Separationist, because this line of cases was one that I was active in Washington, D.C. 20 years ago when the Zellman decision came down. I was sufficiently known on the topic that I was invited to the National Press Club to be part of the debate the week after the Zellman decision came down, and I debated the Catholic lawyer, the lawyer for the Catholic bishops. He was defending the voucher program, and I was opposing it. I argued at the time that I saw the specter of strings and compromise attached to state funds, as well as social divisions and strife that Justice Breyer predicted. I argued that receiving the vouchers, as opposed to what the Catholic lawyer said, may not be good for religious education, could undermine the values and ideals that made religious education valuable and unique. But now, 20 years later, I confess I've changed my view in opposing Zellman. But it is not simply that I've changed my views on that matter, but I believe the society in which we live has rather dramatically changed in the meantime. I do not believe that my core principles have changed, but that the application has changed in response to changing times. 2 decades ago, it was still possible to talk about religiously neutral public school spaces. But is that really possible any longer? With the rise of secular, sexual, and gender ideologies, revised views of the family, the continued rejection of all but the most materialistic explanations for the origins of life and humanity, and opposing views of human nature, can public schools really be described as religiously neutral spaces? And it is on this point that I think Justice Breyer may not have seen the elephant in the room: the current existence of massive social strife over basic, metaphysically rooted social and human values. Social strife over religious and metaphysical ideologies is not a remote future possibility. Rather, it's an overwhelming present social and cultural reality that has rocked our country over the last 6 years in very dramatic ways. Many people don't feel represented by the reigning secular ideologies. And instead of being neutral in this debate, the state has largely placed its great weight and resources squarely behind the secular humanist version of creation, anthropology, family, gender, sexuality, racial origins, and so on. Once this larger picture is understood, there's a reasonable argument to be made that providing state resources to fund educational ideologies, and I think this is an important point, based on the free and independent choices of parents. Right? It's not the state deciding which religion to support and not support. It's rather the state providing resources to parents who decide which ideology they want their children educated in. Currently, in many states, parents are forced to send their children to schools based on, for many of them, an alien worldview that rejects many of their deepest faith commitments, practices, and teachings. And think about this. It's their money. We all pay taxes. Our taxes now go almost universally on the educational front to a largely secularized school system. What's so wrong if a few of the people who've paid those taxes use them instead to send their children to schools that are consonant with their religious beliefs? What about the possible corrupting effect of the state aid on religion? Isn't that for religious people and institutions to consider and worry about? Indeed, in the state of Maine, Maine has set down strings relating to sexual and gender ideologies that the religious schools there find unacceptable, and they actually won the case at the Supreme Court, but aren't taking the aid. Now, that, I think, could be challenged, and I'm talking with some lawyers about this, that there's a doctrine called unconstitutional conditions, that the government cannot condition a general neutral benefit on somebody giving up their constitutional rights. And certainly these schools have rights to freedom of expression and belief and association that may undermine those restrictions. It's interesting that 3,000 years ago, the book of Proverbs advised, when you sit down to eat with a ruler, observe carefully what is before you, and put a knife to your throat if you are given to appetite. Do not desire his delicacies, for they are deceptive food. Right? There's no such thing as a free lunch. When the government gives you money, it wants something. But maybe it only wants educated children. And it doesn't say don't eat with the ruler, it says consider carefully. I think Ellen White, who was more pragmatic on this than I thought when I was a young man, had this to say about our current era. The Lord still moves upon the hearts of kings and rulers in behalf of his people, and it becomes those who are so deeply interested in the religious liberty question not to cut off any favors or withdraw themselves from the help that God has moved men to give for the advancement of his cause. That's in Testimonies to Ministers, page 202. She talks about not just private citizens, but public and civil rulers who might give resources. Now, just to prove that I am still a church-state separationist, even though maybe a somewhat humbled and chastened one, let me talk about a second case. On June 27, the court ruled in Kennedy versus Bremerton School District that Joseph Kennedy, a football coach at a public high school, had the right to pray on the 50-yard line immediately after the game. They said that his free speech and free exercise rights protected this moment of personal prayer and attention. Now, the court was very interested in the history of civil rights and religious freedom in setting its standards, but they seemed disinterested in the history of this particular episode. There were three final episodes of the post-game prayer that none of his students attended. He was alone, sort of, not with his students anyway, in the middle of the field. But what the court didn't, only the dissent pointed out that this was a continuation of a practice that had occurred for several years, where he prayed in the locker room, accompanied by overtly religious sermonettes. Given this history and context, the actions of the coach in endorsing and subtly coercing his students, what student athlete isn't looking to curry favor with the coach to get more playing time, right? It's basic human nature. Indeed, these final alone prayer sessions were not truly alone. They'd become causes célèbres politically. He was accompanied not by his own students, but by students from the opposing team, as well as by local political officials, state political officials, all anxious to wrap their political bona fides with the sweet sacramental incense of football and prayer. Kennedy's behavior did not bring peace and unity. His religious actions caused division. He was the assistant coach, and the head high school coach resigned, expressing concern over threats of violence generated by the controversy, and 3 of the 5 assistant coaches left as well. In light of these facts, it seems fair to ask if prayer is being used as a political football by sincere, but in my view, misguided religious zealots, rather than as a genuine devotional exercise by Christians trying to bring peace and unity to their communities. I teach at a seminary, and I believe that prayer is generally a very good thing. But can prayer become politicized and even weaponized so that social and religious minorities feel excluded from the larger community? If and when this happens, prayer warriors risk becoming prayer bullies, something that Christ had rather strong things to say about. Better, he said, to pray in your room at home than on the street corners or football fields. Well, he actually said synagogues, but football fields are essentially the temples of our day, to be seen by others. These, Christ said, have received their reward. Some Christians wonder if the praying high school coach is like Daniel, who was thrown to the lions for praying at his window. But unlike the coach, Daniel's prayers, though observable by the public through his open window, were in his own home. Nobody could argue he was doing this on government time or government property. Nobody was stopping the coach from praying in his own home, in his car, in his office, even quietly on the sidelines. He wanted to elevate his prayer into a public ritual, using a platform that only he had by virtue of a state job. Given sufficient official leeway, it's all too easy for prayer to be used for bullying rather than community building. For the court to find such behavior protected under the First Amendment is, in my view, troubling and signals a new and concerning era in the Establishment Clause jurisprudence. But just to conclude, I think it's important to acknowledge that along with these more controversial cases that split along ideological lines, the court has ruled nearly unanimously or unanimously on some other religion cases this term. The rumors of the court's complete ideological split and capture by the far-right ideologies are perhaps somewhat overstated. In Shurtleff versus Boston, the court unanimously ruled that when the city of Boston allowed private civic and social groups to fly their flags in front of City Hall, that it could not exclude Christian groups from participating. This can mostly be seen as a victory for public expression and freedom from religious discrimination. It was a 9-0 decision. Also another case, Ramirez versus the state of Texas, the court ruled that an inmate in a death chamber had the right to be prayed over and touched in blessing by a minister as the fatal drugs were administered. This was an 8-1 decision, with, ironically, the lone dissenter being one of the arch-conservatives, Clarence Thomas, who apparently is so pro-death penalty that he doesn't want religious practices to slow it down. Finally, there is the most recent case, the very last week, in fact, yesterday. Yeshiva University is an Orthodox Jewish university, and the New York State Court had ordered it to recognize a student LGBT club. About a week and a half ago, Justice Sotomayor, one of the court's liberals, actually issued a stay, at least temporarily, choosing religious freedom over the LGBT rights. Perhaps just as surprisingly, two of the conservatives, Chief Justice Roberts and Justice Kavanaugh, sided with her and the other liberals in choosing to dissolve the stay just yesterday. Instructions were given, though, that an expedited stay should be sought from the state courts, and if it was not obtained, that Yeshiva would be welcome to return to the Supreme Court, where we know there are at least the 4 votes needed for a full review. Now, this is a difficult situation for Yeshiva in the short run. This weekend, the news broke that in order to honor its religious convictions, Yeshiva is suspending all its student clubs. So there is no student club to treat unequally until the courts finally rule on the case. In the meantime, I think we should take courage from these joint decisions where the court has ruled together and where liberals and conservatives apparently cross over to the other side. It seems that while our dissenting Protestant heritage that I spoke of earlier is not expressed strongly these days, there is still a residue of it on both sides of the court. There are values of liberty, freedom, and equality that we resonate with on the left side of the court, as well as values of ordered liberty, family, and life that we appreciate on the right. I believe that as Adventist Christian lawyers, we are called not just to work generically in the law for 5 or 6 days a week, and then try to reconcile ourselves and other people with God on Sabbath or maybe at prayer meeting, but we are called to be reconcilers and bridge builders in our very profession, practicing not the politics of dissension and division, but rather looking for common ground and an appreciation and respect for all. Ambassadors and reconcilers for Christ, not just in our homes and churches, but in our workplaces and public square. May God bless our church and our universities as we seek for these things.
Thank you very much. Nick, I'd like to invite our panelists to come forward, take a seat at the front. I will briefly introduce them. So after I introduce the panelists, each will sort of have a comment or a statement about a particular issue that is of interest to them as it relates to the Supreme Court and some decisions, and particularly how it might impact their work. And after that, as I said, we'll have some time for some questions and answers. So you can just sort of indicate who you are. I'm sort of reading this in sort of alphabetical order. So first we have Orlin Johnson. Orlin serves as the director of the NAD Office of Public Affairs and Religious Liberty. Before that, he worked at a number of firms where he led and co-led teams that focused on a wide range of issues, including corporate governance and securities transactions. In addition to his legal practice, Mr. Johnson was appointed by President Obama and confirmed by the United States Senate to be the chairman of the Securities Investors Protection Corporation. Mr. Johnson received his BA degree from Andrews University and his law degree from Howard University here in Washington, D.C. Bettina Krause is currently the editor of Liberty Magazine, a journal focused on religious freedom that has been published by the Adventist Church for more than a century. She's also an associate director of the NAD Public Affairs and Religious Liberties Department, and previously served as associate director of the General Conference Parle Department with responsibility for government affairs. Bettina is a transplant from Australia and holds a law degree from Macquarie. Okay, I knew I was going to get that wrong. Macquarie University School of Law in Sydney. All right, Dwayne Leslie, who's at the far side there, serves currently as the Vice President and Deputy General Counsel for Adventist Healthcare. He is also the Chief Compliance Officer, where he is responsible for overseeing the corporate compliance, internal audit, and grant management functions for the entire health system. Dwayne studied economics and political science at Andrews University. After graduating from Andrews, he went on to receive his law degree from the University of California at Berkeley and a certificate in healthcare management from the Yale School of Management. Scott Laughlin currently serves as a senior partner at the global law firm of Hogan and Lovells. Am I saying that right? Hogan Lovells, where he is the global co-leader for the firm's privacy and cybersecurity group, which is widely considered one of the top privacy and cyber teams in the world. Individually, Scott is ranked as one of the leading privacy and cyber lawyers in the country and works with some of the world's largest companies, helping them manage and protect their data. Scott graduated from right here at Washington Adventist University, and he earned his law degree at the Harvard Law School. Jennifer Gray Woods joined the General Conference of Seventh-day Adventists in 2015 as an Associate General Counsel, where she focused on the area of trademark, copyright, and data privacy. In 2021, she joined the Department of Public Affairs and Religious Liberties as an Associate Director. Before joining the General Conference, Jennifer worked in Washington, D.C. at the United States Department of Veterans Affairs. Jennifer received her BS degree in biology, which is very important because here at WAU we have a lot of students who are pre-law and biology. I see some of them here. At Oakwood University, and she also has her law degree from Harvard University, where I found out today she was a classmate with Scott. I found that out today, so that's terrific. She also holds a Master's of Public Health from Johns Hopkins University. All right, I'll invite you to come up as well now as we have finished. Okay, so now what I'll do is I will hand over the microphone. I think we're going to start with you, Bettina, if that's okay. And then I think there's another mic around here somewhere as well, but we have two that we can use. And once they have finished, we'll begin entering into a period of some questions and answers.
Great. Thank you so much, Jonathan. It's an absolute delight to be with you this afternoon and to be able to address some of these questions that Nick has raised. It has been an interesting Supreme Court term. It's an exciting time or a frightening time to be editor of Liberty Magazine. I wanted to touch a little more closely on the issue of school prayer, the case of Kennedy versus Bremerton. I mean, in many ways, this has become sort of the archetypal issue of how do we calibrate that balance between someone's free exercise rights and the need for students to be protected from religious coercion, the anti-establishment protections that we need. How do we get that balance right? And so Kennedy really focuses in on those issues. Now, historically, as Nick touched on, the Adventist Church and Liberty Magazine has swum very strongly against the evangelical conservative Christian current on this issue. We have argued for a robust interpretation of what Establishment Clause requires in terms of our responsibility to protecting vulnerable students in a relationship with a power imbalance. You have a teacher and a student, and that student needs to be protected against religious coercion. But that said, there must be a balance, and we have never argued, on the other hand, that all markers of religious identity, that all expressions of religious practice should be completely expunged from the public sphere. I mean, think, for instance, yes, we don't want teachers leading students in the locker room in prayer. We don't want that. But what about the situation where a teacher bows his head over his lunch and says a prayer in view of his students? What about a teacher who reads the Bible, for instance, on a class break? What about a Muslim teacher who chooses to wear hijab in the classroom? What about a Catholic teacher who chooses to wear a cross? We need to be concerned about the balance unless we're prepared to go down the path of, for instance, France, where their idea of separation of church and state, their understanding of a secular state, laicity, is more of a militant version of secularism, where expressions of religious identity are being expunged from the public realm in ways that are, quite frankly, hostile toward religion. So we need to get that balance right. And that is why the case of Kennedy versus Bremerton is so interesting, because the court is examining this issue. It's not a novel issue. And I would argue, Nick, even that the outcome itself in the case is not particularly earth-shattering. It's not a sky is falling outcome if you're prepared to accept the facts that the majority embraced. Because it's so interesting. If you read the decision in this case, the majority opinion embraces one set of facts. The dissent amplifies another set of facts. You'd be forgiven for thinking they are two entirely separate cases. But the really disturbing aspect of this is not really the narrow outcome, but how the majority got there. Because it could have chosen a number of different routes to get to the outcome it got. It could have chosen to apply the so-called Lemon test, or some version thereof, which is a 5 decades old test that has been used in various ways by the Supreme Court to calibrate this balance between the requirements of the Religious Freedom Clause and the Establishment Clause. But instead, the majority chose to explicitly abandon the Lemon test and to replace it with nothing in particular, simply a vague reference to the need when dealing with Establishment and Religion Clause issues to consider the historical practices and the intentions of the Founding Fathers. This is infinitely vague, infinitely malleable. What are the lower courts meant to do? How are they meant to apply? What judicial reasoning are they meant to apply now? And so my concern, my sky is falling concern with Kennedy versus Bremerton is not so much the narrow outcome, but the fact that the Supreme Court majority has issued an invitation, loud and clear, to all those who would wish to test the current boundaries of church-state separation, who would wish to carry the enterprise of Christianising public schools to the furthest extent allowed by the law. And that invitation that has been issued, I would argue, should be concern of all people of faith who understand that true religious freedom requires a balance between not just free exercise, but protections against religious coercion.
Thank you. I think we'll go to Jennifer next. Just a quick word. I'll send this announcement out a few times. If you're interested in some questions, I think what we're going to do is have you email them to me. So for those who are watching online as well, my email address is jscriven, that's JSCRIVEN, at wau.edu. I have a couple already, but as we continue with this, send your questions and we'll get to those. Okay, we'll go next to Jennifer.
Great, thank you, and good afternoon, everyone. I'm going to follow up on Nick's overview of Macon and the issue of funding of religious education with taxpayer dollars. And there are a number of concerns that this case raises, in my opinion, but as this funding becomes more available to religious institutions, the concern that I want to raise this afternoon is the one of whether religious schools will become dependent on these funds in the future, and will the state then be able to place these additional burdens on religious institutions? How will this impact religious educational institutions moving forward with requirements that could come in the future. So what if states begin setting down requirements regarding the teaching of evolution or secularist views of sexuality and gender? These are things that Nick mentioned in his article, which I do encourage all of you to read. And what strings can be attached in the future as this funding becomes more prevalent. And this is not just some theoretical question. We've actually seen this take place even within our Adventist religious educational institutions. There are currently a number of SDA schools that are taking this kind of funding, taking vouchers and other payments, and we've seen in the past where there have been strings attached regarding non-discrimination against LGBTQ, for example. And we've seen where schools have said, oh yeah, we comply with that, and then you look at their handbooks and their policies, and they very clearly do not comply. And in fact, a couple of years ago, some of our schools in this area, they had to pay back funding for vouchers that they had taken because they said they complied with the state's requirements in Maryland, and come to find out they did not. And so they ended up owing money back to the state because they weren't mindful of the strings that were attached to the funding. Another example of this is, again, during COVID with the funding from the federal government. The NAD actually issued a recommendation, and I'll read that. It said, in 2020, the North American Division's administration recommendation is to abstain from participation in the federal financial assistance programs. While the risk associated with the money is uncertain, NAD's leadership's primary concern is remaining faithful to the counsel we've been given regarding church-state relations. Even with this guidance and this recommendation, there were still many institutions that took the funding. And moving forward, what I'm hoping is that our religious institutions will look at the strings that are being attached, because as Nick said, the funding doesn't come without something in return, and maybe it's just the education of the children, but maybe it's something more. And so we want to make sure that we look at what those strings are, and then we weigh whether or not we can comply without compromise of our teaching and doctrine. And I'll leave it at there for now.
Thank you very much. Yes, we'll move on to Orland now. Thank you.
Thank you, Dr. Scriven. The case I wanted to talk a little bit about was the Shurtleff case versus Boston. Ironically, when Nick was starting to talk about it, I started to think to myself, there are a few things in this case that I'm not sure I'll ever see again in my lifetime. First and foremost, a unanimous decision. 9-0 decision regarding this case. This case was regarding, there are 3 flagpoles that sit outside the city of Boston, their city hall. One that has the United States flag, one that has the Massachusetts flag, and one that generally has the city of Boston's flag. However, from time to time, the city will allow what they would call secular flags to be flown in place of the city of Boston flag. So back in 2017, we had Harold Shurtleff that came and applied to fly the Christian flag. And the court came back and said, well, no, we don't want to fly the Christian flag because we believe that that will be a government expression. If it's a government expression, then you can find yourselves in violation of the Establishment Clause. And the points that Bettina was making regarding the separation of church and state, it looked like it was blurring the line. Supreme Court looks at this case and comes to a unanimous decision that this particular instance was not government expression, that it was actually a situation in which it was just a private expression that was being espoused. Now, ironically, the way the court handled this is they said that this is a very narrow view. In other words, not every secular flag that you may want to put in this situation would satisfy. However, now that means every flag that you potentially could be flying, you'd have to come back and do a complete different analysis again. Now, if that doesn't mess you up enough, let me throw this on top of it. There's a group that wondered, who said that's my Christian flag? 1942, this flag gets established by a large group of individuals that call it the Christian flag, where there are others that call themselves Christians that say that they don't relate to this flag. So now you have a flag that's being flown, quote unquote, representing Christianity. You have a court coming to a conclusion that this is a private expression and not a government expression. And then the court is even further saying that this is a narrow interpretation, which means we're only talking about this specific flag. Can you imagine what kind of confusion, as Bettina had mentioned, lower courts would have to deal with when coming through this process again? Now, ironically, as Bettina mentioned, one of the things that they could have done was to actually utilize the Lemon test. The Lemon Test, although it's been around for a long time, has some very clear points that if you look at, you can probably find a way to juxtapose your facts in the case to come to some type of conclusion. The first thing the Lemon Test wants to find out, is there a secular purpose? You probably can find an analysis to get you there. Second thing they want to find out, is this going to be a primary advancement on religion or pulling back on religion? And then lastly, does this foster an excessive governmental entanglement with religion? You could have probably utilized the Lemon Test to come to a conclusion as to whether or not this flag could have been flown or not. But I think one of the things that we're starting to see as it relates to the court is the court from time to time can get vague, but the court at this point is starting to get squishy. So squishy that you cannot tell where we want to be. And the other irony is that there was a time where you would say, oh, well, at least we know where these justices are going to be because they are the quote-unquote conservative justices. But now you see justices that are conservative flipping over to the other side. And I think the dialogue now is the swing votes are Chief Roberts and Justice Kavanaugh. If that's not strange enough, you can imagine how difficult this whole process is going to be. But the irony is that I have been looking at is we are getting to the point where it's very difficult to find a reasonable interpretation of the separation of church and state that we as a body sometimes don't want to grab onto too quickly. What am I saying? Well, sometimes we maybe as Adventists or other Christians can look at something happening in the government and say, you know what, that dovetails with what I believe from a religious standpoint. So as a result thereof, we should jump on board. We should fan the flame. We should cheer it on. But the fact of the matter is, as someone mentioned earlier today, there's only 1.2 million Adventists in the North American division. But there are about 7 million Mormon. There are about 8 million Lutheran. There are about 9 million Methodists. There are 30 million Southern Baptists. There are 80 million Catholics. If all of a sudden everybody starts fanning the flame for what works for them from a religious perspective, let me go back to our number again. There's 1.2 million Adventists in the United States. And that's why it's so important that we have to be nuanced in our support. If we go out and start saying, that works for us, let's cheer it on, what happens when the next group says, that works for me, let's cheer it on? And that cheering it on runs over our personal beliefs. So at the end of the day, finding a way in which you can support and want to see freedom of religion move forward, but not getting caught up in the tool of because it works best for my religion, I'm going to jump on it with 2 feet. So I just want to end by simply saying that there is a time when you would say that we definitely know where judges are going to be. The fact of the matter is, when it comes to the cases of religious freedom, we're probably going to see jumping on both sides of the table for quite some time. And it's going to be very difficult for us to really come to any final conclusions, but it's going to be critical, in my opinion, for us in particular as a church to be consistent in our message. Trying to play both sides of the fence will eventually burn both ends of the candle, and both ends of the candle generally end up burning someone. Thank you very much.
Thank you. Scott, I think you're going to go next. Thank you.
Yep, thank you. So great to be back here at Sligo and on the campus of my alma mater. Thanks so much for having me. I'm going to talk about a case that probably everyone has read about, although Nick did not include in his remarks, and that is Dobbs. I do not want to talk about that in the context of whether we all think that we should be pro-life or pro-choice. Instead, I want to think about it maybe from a religious liberties perspective. And that's the place where I want to go with this conversation. One of the things from a legal point of view that people of faith really hold place great value on is the constitutional protections that we're afforded in our practice of religion. And so whenever there is a case that removes a constitutional liberty, I think that is time to take note that all the liberties that we currently enjoy and that we currently expect are ones not to be taken for granted, because ones that can easily be removed. And we saw that in Dobbs. Dobbs represented the removal of a constitutional right that existed for 50 years. Underpinning that was a number of rationales that also went to, quote unquote, a right of privacy. Now, you may think of that, well, what constitutional right do we have in privacy? And the answer in the United States is very little. We have some under the Fourth Amendment relating to searches and seizures. We do not have much outside of that. Roe v. Wade was one example where the court had said there are some decisions that are so intimate that we want to protect that in our Constitution. Griswold was another case that talked about contraception. Another similar example, the right of privacy driving the idea that the government shouldn't be in the position of abolishing contraception. Lawrence with privacy in people's bedrooms, another privacy-oriented case. And all of those cases were rooted in the same rationale of the Due Process Clause of the 14th Amendment. And that was the same rationale that was designed to protect abortions in Roe v. Wade. So as you see the court now looking at what the 14th Amendment says, and now saying, well, we are going to review how previous courts have come to a decision about what is protected under the 14th Amendment, we cannot automatically assume that all of the other constitutional rights that we have will continue to remain in the same way that we have them today. And being a privacy lawyer, this is a sensitive issue for me because it really came home, or it really was connected when we were watching the fallout of Roe v. Wade and the Dobbs decision. The executive branch, President Biden had issued an executive order soon after the decision, calling attention to when people are providing information about themselves to things like apps, which would track menstrual cycles, or providing information to healthcare providers, which could be subject to law enforcement requests, or any other information that may be collected about you on the internet. One of the things that they called attention to was a thing called SDK. It's very technical, but you think of it as a piece of code that they put in an app. Maybe it's an app that would generally have access to your location data. What's an example of that? A weather app, for example, could have access to your location because you want to know what forecast to deliver. Instead, I want to know what the weather is going to be like in Tacoma Park instead of in Tulsa. Embedded in some of those apps is code that allows those apps to provide that location data to third parties. And so Senator Warren was saying, hey, are you guys collecting data so that you can now then make available to the government about who went into an abortion clinic? Companies went out and said, no, we're not going to do that anymore. We're going to outlaw that activity. But that really got you thinking about how that could connect to our daily lives as a people of faith. So for example, in other cultures or in other areas, you would say, does the government want to know who goes to gun ranges? Probably. Does the government want to know who goes to mosques? Does the government want to know who goes to church on Saturdays? Right? That slippery slope should make all of us very wary whenever the court decides to take away a constitutional right, regardless of whether you think that Roe was correctly decided.
Thank you very much, Scott. We'll finish now with Dwayne.
So I'm also just going to touch briefly on the Dobbs case as well. And Scott really outlined, I think, some of the important issues that are things that I think about, too, in my role, working for Adventist Healthcare, which is one of the large health systems here in this area. And so, it doesn't directly impact us from a healthcare perspective, because just to be clear, we don't do elective abortions at our health system, and we don't think that's going to change after this opinion. So I want to just be clear about that. Scott mentioned privacy issues, and in my role also as Chief Compliance Officer focused on healthcare privacy, I'm also very interested in what happens to these apps and how those can be interpreted and seen by governmental entities, or just even protecting individual privacy. I think that's something which is very interesting. I think people haven't thought about it completely. I think there are unintended consequences of how privacy will be addressed in these apps, because people haven't thought about it, and I think it's going to keep people like Scott very busy. Your legal practice is going to be quite robust going forward. I think one of the issues I want to raise is how with this decision, and again, obviously everyone has an opinion on it, but what has happened with taking this to the states, we've now seen a huge debate state by state. So some states they had trigger laws which immediately restricted abortion upon the repeal of Roe. And then you have states like Maryland, which have really gone to great lengths to strengthen abortion protections. And so again, you have disparate treatment depending on where you live, whether your rights are protected for abortion access or whether they're restricted. And so I think we're going to continue to see that play out over time. And even in Maryland's rule, the first in the nation, they're sort of mandating permanent state-funded abortion care clinical training program in the Maryland state budget. And it remains to be seen how extensive that's going to be, what restrictions are going to be tied to that or not. But I think we're going to see these kind of debates play out in state after state throughout this country. Just one other point that I want to raise is we've seen religion over time be something that can unite people of faith. But what we're also seeing in some of the arguments that have been raised is there are religious liberty arguments being raised on both sides in the abortion debate. Who's right, who's wrong? How do you balance these competing interests effectively? Because everybody feels strongly about these kind of cases. And so I think it's just going to be interesting to see how it comes together. And Orland mentioned too, what happens in balancing individual religious rights in certain matters. And for some people, they say, well, why should the religious views of a plurality of people govern public policy? Let's see what happens.
Thank you. I'll invite Nick to come join us. And once again, last announcement, I promise. But for questions, I've received quite a few already. Please email me, and I will try to pass them along. jscriven, JSCRIVEN, @WAU.edu. Nick, did you have anything you wanted to comment on some of the things that have been said so far, and then we'll get to our first questions?
Yeah, just a couple of quick things. I share Bettina's concern about nobody really knows what the new Establishment Clause standard is. Lemon was not a perfect test, but it had some significant guidance to it, and it lasted for 50 years. And now the court has said two things. You can't use coercion in religious matters. This harkens back to Justice Kennedy in the 1990s proposed a coercion test, and the court largely set it aside and ignored it. So in shorthand, coercion is you can't have an inquisition. So that seems like pretty basic, and it doesn't go very far. Beyond that, beyond you can't have an inquisition is this vague, we allow things, we have to look at the history and traditions of our country. And that's going to change depending on what judge you're before and what court you're before. So it is very troubling. There's going to be a whole lot of litigation in the Establishment Clause area without much guidance at all. And I will just say to Jennifer's comment about the CARES Act funding, that I thought it was interesting that our leadership, who I support and respect, but don't necessarily always get everything right, they said protecting our heritage and tradition of keeping church and state separate, but I just read to everyone here a quote from Ellen White that said, God moves on the hearts of, and to my mind, of rulers to support at times the church. And to my mind, the churches had been disadvantaged by the government by an order requiring them to close their doors and not to meet. And the same had happened to businesses. And so rather than the government giving something that wasn't owed to churches or businesses, it was the government creating a burden initially in the public's interest and then choosing to remove that burden and make them whole. So there were several of us, my union actually moved ahead and got the funds, but didn't do that by ignoring our heritage and history, but perhaps had a different reading of it.
Thank you. So that leads into actually the very first question I actually got, and I think this is going to be a little bit more for the left side of the panel. It's a little bit of a denominational process question. So how is it, the question is essentially this: how does the church make decisions about how, when, and why to officially comment on things like Supreme Court cases or policies that are coming through at either the state or the national level?
Well, and that's a very good question, and I'm glad somebody raised it. First and foremost, it should be crystal clear that it's not done by one individual who sits in an office that just decides to move forward on their own personal convictions. There's a lot of talk from time to time that depending on the personal convictions of an individual in leadership position, that's how decisions are made. And that is far from the truth. First of all, we have a collaborative concept that we always use, in which we bring together a group of individuals, for example, to take a look at cases. In terms of court cases, we have what we call an amicus committee, in which we sit down and talk about potential cases that we look at to wonder if the church should get involved in it, because there's a decision that's being made, for example, at an appeals level or at the Supreme Court level, that may have the type of voice that we want to make sure that we're at the table. And so we also have a litigation committee where we actually represent and assist individuals who are church members and some who are non-church members that have religious liberty issues that come up. And I think one point that is important to make is our determinations are not simply made to just simply help Seventh-day Adventists. Our determinations are made to help anyone that is finding themselves with their religious freedom infringed upon. And I think that's a role that our church has taken on for a very long time. So our committees come together, we take a look at all that's available, we try to provide counsel, and we try to provide counsel based on the information that's available to us at that time. You know, we come down the road and we may see certain things that change, and sometimes we have to come back and look at our analysis and our recommendations that they have to change. But they're not done in a silo. We try to bring as many departments together as possible. We usually have a conversation, for example, at the North American Division with the General Conference of the Seventh-day Adventist Church. My office works with Jennifer's team on a regular basis, so that hopefully when we are going out and making a statement that we are in a position where there's a large agreement that's taking place. But let me be clear, and I tell people this all the time, it doesn't matter what statement that we make that comes out of North American Division, half the church is going to be mad. Doesn't matter. Because the fact of the matter is, we're not a monolithic church. We have many different points of view, and what we try to do is hopefully do that in a balanced way. However, it is our goal to always be at the table. It is our goal to always be there, to be involved. And my favorite saying is, you are either at the table or you're on the menu. Pick which one you want to be. And we would prefer to be at the table, hoping to shape policies moving forward.
Okay, thank you. I'm going to just drill down one level. So that was a very good overview. So, Nick, you sort of made a reference to this, but another question that came in is involving things like COVID relief and CARES Act. How is that process determined? In other words, does the church make a statement broadly, or are these decisions that are made at the union level, at the conference level, school level? How does that play out?
The same collaboration I was talking about, it would be, for example, our executive committee, the North American Division, in council with our union leadership. To be honest, most of the time we make these statements, it's usually at a request of a union that wants us to help them with some clarification of how they should move forward. We don't sit around looking for opportunities just to engage in those conversations. Usually we want to try to give them the best information possible. You know, we are at an advantage because we are in the Washington metropolitan area where a lot of these activities are taking place on Capitol Hill. We have a liaison at the World Church that works in Washington. We have a liaison at the North American Division that works in Washington. So we try to make sure that the boots on the ground that we have is giving us the best information possible. But at the end of the day, we are making recommendations. And the reason we're making recommendations is we're not trying to give edicts, because there are very different circumstances all across the division. All we try to do is say, based on what we see, using our biblical points of view and what we have seen in the past, is try to make a recommendation. The idea, for example, regarding the CARES Act funding is we would say, well, it doesn't appear to be any strings attached. And right now it doesn't appear to be any strings attached. But if you want to get a recommendation as to how would we best say to move forward, and maybe that's the former attorney in me, that it's always easier to say no. And so that way you can always push to go closer, but no is always safe. And I think we were probably more in the slow down the process. We would recommend that you not move forward. But we also told all of our unions to make a prayerful decision in deciding. And if during prayer and their counsel they decided to move forward, we would trust that that's exactly what they did.
There are a lot of questions coming in that address a lot of the different issues, so I'll try to move around as much as possible. This one's a little sort of broader. So one of the questions that came in on the email is, it's actually very broad. How do we, or how should we distinguish between religious freedom and discrimination? Who wants to tackle that one?
So between religious freedom and discrimination, well, I saw a posting earlier this week that said when it's a religious exercise that you want to carry out and you're being stopped from doing it, then that's religious freedom. When it's a religious belief that you want to impose on others, then that's discrimination. But I think that answer is a little bit simplistic because a lot depends on what you mean by religious. In terms of, some people would include under that your moral beliefs. You know, whenever you want to impose your moral beliefs on other people, that's a bad thing. Well, was slavery a moral issue? I think it was. And a good part of the country decided that moral freedom did not allow certain people to keep their property as people. And there were the moral convictions of, in good part, many Christians were abolitionists, and they viewed this not as a question of spiritual morality or just biblical teaching, but a question of basic humanity and civil morality, and therefore they felt that they could invade and oppose these claims of right, and they could use their morality. And in fact, the separation of church and state that developed in the mid-20th century wouldn't have been recognized by our pioneers to some degree because it was developed in parts, the extreme version, in the southern United States, where there was an attempt to keep the church out of first critiquing slavery and then critiquing Jim Crow laws. And there was this, no, separation of church and state, you can't raise moral questions.
No, I think that was a very good answer. So, Bettina, you have the microphone in your hand. So, related to all this is your position as someone who puts out a magazine that chooses what topics to address and look at. Could you just talk a little bit about the process of how it is that you and your team make decisions about what issues are important enough to be put into Liberty Magazine?
That's a good question, and it goes to what is Liberty Magazine. And it is not a magazine of polemics or of diatribes or of us trying to, as a church, as a denomination, trying to dictate to others what they should think or how they should relate to issues of church and state or religious freedom. It is a magazine of ideas, grounded in certain principles, but a magazine of discussion. And let me give you an example of that. I mean, we've been talking here today about the Bremerton case, the Kennedy prayer case. The most recent issue that came out, we had an article by a very well-known national constitutional lawyer arguing that any affirmation of prayer in public school settings would be the beginning of the end for separation of church and state. In the next issue of Liberty Magazine, we're having running an opinion piece which takes a position that is more nuanced than that. And then the issue after that, we're going to have a discussion on the demise of the Lemon Test, which is also related to the Kennedy case, which provides yet another layer of meaning to that whole discussion. So what I'm trying to say is that while our magazine is solidly grounded in the idea of separation of church and state and of religious free exercise, these are issues where we understand that people of good faith can disagree, and we are prepared to engage in those discussions. And by engaging in those discussions, by laying open the different points of view, we hope that it will encourage people to form their own opinions and conclusions and enter the debate as well.
Thank you very much. The next question, I'm going to move to healthcare, so I'm going to be more on this side of the room. So a sort of broad question, and maybe Dwayne will start here, is what is the impact that church-state issues have on healthcare if you're a healthcare organization that is one of a religious nature like the Adventist system?
Well, at this point, I will say that we haven't really had those kind of, I think what they're saying is, are there restrictions on how we can provide health care to the community that possibly would conflict with our Adventist beliefs? To date, that has not been the case. So obviously, one of the things that we provide care to everybody. We don't discriminate. If someone needs medical care and assistance and they walk into one of our hospitals or any of our facilities, we treat them, period, full stop. And I think that's the way it should be. Because again, Christ's healing mission, we try to heal everyone. Now, there's talk all around whether there are going to be future restrictions placed on healthcare systems, particularly those that are faith-based. I'm not sure what will happen with that, but we have not seen that to date, and I don't think we're really restricted in how we have been treating patients that come through our door.
All right, thank you. There's a number of questions that are coming in on a couple of key issues related to discrimination, particularly with LGBT, and of course that's a very big topic now. So I'm going to sort of synthesize them, and this is sort of for anyone. But does the church have an official policy requiring our schools to either condemn or not condemn LGBT orientation? And if not, should we adopt a non-discrimination policy that protects LGBTQ students and thereby allow the schools to receive government money?
Well, I can answer that first part, and that is no, we don't have a statement directing our educational institutions to discriminate against LGBTQ students. And I think we can pass it down for some more.
What was the second part of that?
One second. The second part is, should the church develop or adopt a non-discrimination policy that protects LGBTQ students and thereby allow the schools to receive government money?
Sure. Well, I'm going to be very frank with this. I think one of the issues that we as a church are really grappling with is there's a view from society that churches have a tendency to create hierarchies of sin. In other words, there are certain lifestyles and sins that are viewed as being worse than others. I think one of the things that we're trying to do, in particular at the division, is to kind of come back down the line and be clear on the fact that we have specific beliefs that we have regarding same-sex marriage from a church perspective that are not changing. Our beliefs are our beliefs, full stop. However, we are still, first and foremost, also supposed to be about a church of love. And the idea of not loving your fellow man because they're engaging in a lifestyle that conflicts with what you believe from a faith standpoint is not being Christ-like either. So, for example, 29 states in the union would allow somebody from the LGBTQ community to be asked to leave an apartment where they live simply because of their lifestyle. Well, we as a church would say, well, no one should be put upon to leave because of your lifestyle, but because I say that doesn't mean that all of a sudden your lifestyle now should be completely in line with what we do as a church. It's a nuanced thing that I think we're trying to make clear, and sometimes it's trying to be handled with a sledgehammer when in reality it has to be handled more with a scalpel. What we are saying is the same thing Christ would say, that you can despise the sin and still love the sinner. So the idea is we can love our fellow man, we can be the first to go out and say that we shouldn't put upon each other, because I believe the Bible says that one of the defining characteristics of one day seeing Jesus, when people were hungry, did you feed them? When people were naked, did you clothe them? When people were in need, did you come and help? And so the idea of what we are trying to do is to make sure that any laws that are crafted in any place will not infringe upon our religious beliefs that are grounded and not moving. But in the same breath, we don't want to be part of what I would call a mob of individuals that is going to be pushing back on a group simply because their lifestyles are in conflict with what we believe as Seventh-day Adventists.
So I'll just add to that to underscore what Jennifer said earlier. No, there's not a mandate that we condemn LGBT persons. And in fact, at Andrews University, we have and I'll put this very carefully, a care group for LGBT students. And it's not a student club. It's operated by faculty and staff, and they help oversee it. And it is meant to operate within the biblical framework of the Seventh-day Adventist Church and belief. But we also recognize that this is a community that is subject to more extreme pressures than many of our other students, have higher suicide rates, and it is, we think, the ministry of compassion to provide them an environment. The studies show that where individuals can share with others their journey and their difficulties with their identity, that these issues of depression and suicide are lessened. Again, we recognize the group, we allow them on our campuses, but we hold them to the Adventist biblical lifestyle standards and teachings. And as far as that second question is concerned, second part of the question about government funds, it's not necessary, at least in most states. So in Maine, that's true. But under Title IX, the federal government policy has an exception for religious colleges and universities that allows students to get government funding from federal government. Again, this is indirect funding, loans and grants, and use them at religious schools. Now, currently, there's some LGBT activist groups that are challenging this. I'm actually involved in litigation in the state of Oregon, defending the constitutionality of that religious exemption clause, and it's very important. Most of our schools would close if we no longer had that exemption. Something like 80% of our students rely to some degree on federal loans and grants. And who knows what will happen with the litigation in the short term, but we have a certain amount of confidence. You know, one of the good things about a conservative Supreme Court is we'll probably retain our protections on this front. So no, we don't need to change our policies in most places to receive federal funding.
Well, actually, I have a great follow-up to that, and that is that in one of the examples I gave with one of our schools that did take funding, they did end up having to change their policy because they were told, you know, you're not supposed to be discriminatory in your acceptance of students, whether or not they are of the faith or not. And so this particular school said, you know, if you have atheistic tendencies or make light of religious matters, you should not apply for admission. And that school then did end up changing their policy to be more inclusive in the sense that we welcome everyone to come. Now, we have certain standards and doctrines you have to abide by while you're in the school, but as far as who can come, that they have to become more open on in order to receive the funding. And that may be something that schools have to look at in the future as far as the wording of their policies and their handbooks.
Thank you. Moving to a sort of a historical question that sort of has two parts. The question coming to me through the email is, did Adventism move away from school segregation because of the risk of losing government funding? And in other words, is all strings attached necessarily negative? And how do we address that?
Well, you know, there's an irony about the government putting rules and regulations in place. So, for example, when I want to go out and let pastors know that they shouldn't allow any type of activities to come into their church that may be viewed as partisan politics, on one hand, they would love to ignore me. But the only club I have is, if you do so, the federal government may come for you, and we end up losing our exemptions and things of that nature. And for some reason, they're more afraid of them than me. So ironically, you do have these times when the government has the ability to really help to move things in the right direction. However, I think it's also interesting to point out that our church has also gone through an evolution the same way that, you know, the United States has. I mean, you know, we started out as a confederation of states, then we're moving into the United States of America, and some of these laws that we're starting to see are trying to put us back into being a confederation of states again. And I think one of the things that we have noticed is as we moved along, as things have changed, we have made decisions that hopefully will continue to be in the biblical realm. And I wouldn't say that our issues are changed because of government activity or the threat of government, but because as we continue to seek the Lord in prayer, to look to make sure that we are going about things in the right way, and also getting more of an inclusive voice, it helps us to make better decisions. And I think as that voice gets more inclusive, better decisions are being made, and I think that, in my opinion, would be the primary thing that moves us forward in some direction.
Here's sort of a broad constitutional question involving the Supreme Court, and I'm very pleased that people are sending these from those of you listening online. How likely is it that the movement to increase the number of Supreme Court justices will succeed, and what, if any, impact might that have on religious liberty?
I mean, the answer is I have no idea how likely that is. I mean, I would hope it doesn't happen, only because it is going to result in the next person doing the exact same thing, and it's just going to end up, happening over and over and over again. And the Supreme Court, which is designed to provide more stability and more generational kind of views of things, will look more like the legislatures with turnover and the increased number of people, and be more responsive to immediate demands than it would be, designed to provide stability over the course of decades, if not centuries.
Nick, speak to the point that, our courts, we've actually had what I would call a conservative court for quite some time. And if you look at who has been making the appointments, all of a sudden we now start to feel that it's even a harder lean. But, and I was going to ask Dr. Miller to speak to this notion that when you come on the court and you're perceived to be one thing, that's necessarily what you're going to be for the next 50 years, has not been exactly how this has played out. And so, and I'm one of these individuals where I'm always interested when people say, oh, well, we got this justice now, so we know how they're going to vote. And we had just sat here and talked about Kavanaugh and Roberts being in one side of a camp that people didn't think would be on camp. So I think it's a little bit more nuanced than what we think. This idea that we've got a conservative court because of who has appointed them, but we have a lot of these same justices that are making moderate decisions that were appointed by quote unquote conservative presidents as well. But Nick, I was just hoping you could speak to that just a little bit.
Yeah, well, the surprise trajectory of justices has been an ongoing phenomenon, especially on the conservative side, I think. Thinking back to the days of, you may remember David Souter. Yep. Was a conservative appointee and became one of the strongest left-wing members of the court, sort of a New England libertarian who had what many people consider to be ultimately a liberal outlook. Kennedy was considered very conservative to begin with, and then became kind of the swing vote on the court, and ultimately overturned the Lawrence decision and joined the majority in the gay marriage case, which shocked many conservatives. So I do think that the court has shifted conservatively in a more decisive way. Mm-hmm. But, Amy Coney Barrett is a Catholic, but I wouldn't be, she comes from, the Catholic Church does have a strong conservative judicial outlook, or some Catholics do, but they also have a strong social justice heritage. Yep. Justice Barrett has some adopted children, minority children, and you would think, and in fact she voted, I think, in the immigration case recently in what you might consider a progressive way. Mm-hmm. Kavanaugh surprised me with being one to dissolve the stay in the yeshiva case. And then looking at the liberal side of the court, Sotomayor is a Catholic. And while she may be liberal in her political views, surely she cares to some degree about the freedom of the Catholic institutions to have their identity. Our new Supreme Court justice is a Protestant, mm-hmm. and is I read that she's on the board of the Montrose Christian School, which back in the 90s had issues regarding LGBT concerns. Yep. So I agree with you. These are rounded persons who can't be predicted all of the time.
Thank you. I'll just finish with one question. We're just up at our time. And this is sort of for everyone, and then I'll maybe, if there's someone who'd like to have a closing, just a statement, and then we'll close. So according to new research from the Pew Research Center, America's Christian majority has been shrinking for years. We know that. Christians accounted for 90% of the U.S. population 50 years ago. In 2020, that figure fell to 64%. Is that trend good or bad for religious liberty?
Well, I think it's a trend that is evolving what people view as being their religious liberty. You know, when you start thinking about, for example, the concept of Christian nationalism, the fact of the matter is their real religion is being American. And when you start to take a look at the fact that that phrase ties to the word Christian, which means that Christ should be at the foundation of it, that's not exactly how it operates in practice. So I think the reality is what some of us are calling religion today was not what we called religion before. And so the idea of whether or not this is increasing or decreasing or a good thing or a bad thing still goes back to the intent of the individuals and their actions that they engage in. You know, as I look at a lot of the activity, the other number that Dr. Scriven didn't mention that has gone up is the percentage of atheists, I believe, has gone from about 10% to 25%. So that increase now also explains what's going on. But then you have individuals that will call themselves religious but have no affiliation with any church. And so it's gotten to be so nuanced and confusing as to what you deem to be your religious beliefs that in many instances is really just your moral compass that somehow has a religious bent on it. So I would say that the numbers are moving, but I think the places that the people are moving are unclear as to what they mean when they get there. And I think that's what I've seen.
The study that you referenced, Jonathan, was also referenced by Justice Alito when he travelled to Rome a few months ago to give a speech at a religious liberty conference. And his point was that it's very hard to make the case that religious freedom should be protected when people don't believe that religion is special. And I think that, you know, from the 10,000-foot view, that makes a very good point, because we are headed, I mean, the trajectory is, I think in about 20 or 30 years, Christianity will no longer be a majority religion in the United States. And so things that we take for granted now, assumptions that we make, and the Supreme Court wins for religious freedom that we're currently discussing are ephemeral, really, when you think about it in the long-term context, because eventually we as people of faith will have to make the case for why religion is special enough to be protected, and we'll need to make that case to people who are secular in their outlook and who in many ways feel that religious freedom is in contest with other fundamental human rights, like the ability to be free from discrimination. So we are facing, in the long term, a very hard sell. And from my perspective, I think we need to start engaging in positive actions right now in making the case for why religion is good for society, why we contribute to society in positive ways, not just as antagonists in the Supreme Court, because that just gives us a bad reputation, quite frankly. We need to be making the case for why religion is special enough and valuable enough for society that law needs to protect it in the long term, even when we are not a majority.
No.
We can go down the line and start making final comments.
No, I agree completely with Bettina. I think that we're going to have to make the case to the non-religious, those that don't identify, as to why protecting religious freedom is important. And I don't think we're doing a good job just overall as Christians when we're saying our rights are the only ones that matter, and it gives us the right to discriminate against anyone who doesn't believe the way that we do. And so I think we do need to think a little bit beyond ourselves when we think about how do we make the case that religious liberty is an important thing for all of us to protect.
I think that's exactly right, Jennifer. I mean, I would add that, you know, in that statistic, it's not that everybody who doesn't fall within that 65% is non-religious. It just means that they're non-Christian. And so the more that we start thinking about legal frameworks that are designed to protect religion and people of faith as opposed to Christians and the Christian faith, is the way that message is really going to start to resonate, because it's going to broaden the tent, and it's going to create a more inclusive environment, and it's going to be left more to the individual to practice his or her religion, as opposed to trying to have that being forced upon anyone else.
So I want to agree with Bettina with what you said. I mean, I think our increasing diversity in this country is a positive thing, and hopefully it makes us more tolerant of people with different beliefs, different religious beliefs. And I think, but one issue, to your point, is I think Christianity oftentimes have overreached in terms of trying to say, well, this is the way that it should be based on our faith, and they use religious liberty as a mechanism for that. And I think that has driven some people away. That's why I think we're seeing the number of people who identify as secular or atheist go up. I think many of it has been a response to some of the abuses that we've seen in the faith community. And so hopefully we can be more tolerant, be more loving, and I think that will ultimately save the day. But Bettina, I agree with your point, is that we have to really be conscious of this going forward.
So in closing, I will say, slightly different topic, I'm going to wade in where angels fear to tread on the abortion question, because there have been concerns raised about the reasoning used in Dobbs, and I actually share those concerns and join you in your expression of those. But I do think we need to acknowledge that on the other side of it, there are some people who view this loss of a right as, in fact, the gaining of the right by babies, by fetuses. And I think as a church, we do acknowledge that prenatal life has certain rights. How we define them is probably not entirely as was as set down in Dobbs. But I do think that it's important. The District of Columbia is not far from here. I looked at some statistics, and there are some parts of the country where 30 to 40% of abortions are terminated, 30 to 40% of pregnancies are terminated by abortion. In the District of Columbia, it's nearly 50%. Those figures would suggest that these aren't just exigent emergency cases with rape and incest and life of the mother, but that there is a culture that has developed using abortion as a form of, nearly a form of birth control. And I think that any approach to the law which completely disregards the rights of the fetus is not proper. Roe did need to be revised, and now it's left up to every state. And I think as Adventists, we have to articulate a truly pro-life position that takes into account both the life of the fetus and the life of the mother, life and health of the mother. Statistics show that where abortion is not available widely, that birth deaths of mothers are considerably higher. And so we have to be pro-life, but we can't just be pro-fetal life. We have to be pro-mother's life, as well as pro-life of children after they're born. And I think this is a moral topic that we as Adventists haven't fully come to grips with.
Well, Nick, it sounds like you're searching for the middle ground, and that's, of course, what we're looking for, some middle ground. Listen, I want to say a very big thank you, first of all, to our panel. Also to my colleagues here, Bradford Hawes, who's in the back, and Nick here, thank you, who helped put this together. Listen, as someone who teaches political science and teaches government and is the director of something called the Center for Law and Public Policy, these are exactly the kinds of discussions we need to have more often in public like this. And Nick and I and Brad are already working on some other events like this, because this is something that is good. So thank you again, everyone. It was just an extreme pleasure to listen to you. I'd like to also take just 1 second to say thank you to our Vice President for Integrated Marketing Communications, who's in the back, who's doing the live stream, along with his children behind the cameras. So let's have a round of applause. Obviously, this could not happen without them. So again, thank you very much. I think if I'll invite people to stand, and Nick, if you'll offer a closing prayer, then we'll be finished.
Let's bow our heads. Dear Heavenly Father, we come before you this afternoon as your children, diverse backgrounds and nationalities, genders, and races, and yet we are all called by you to understand more fully and to help in the expansion of the kingdom of God. The spiritual kingdom as we understand it, but we know these spiritual truths and values have a meaning for our role as citizens and our understanding of morality in our communities. Help us to more fully and faithfully understand these things and be ready for your coming soon. In Jesus' name, amen.